State of Wisconsin versus Cassandra Belland. The state appears through District Attorney Kevin Schmidt in person. Ms. Belland appears in person with counsel Micah Paul by video conferencing. We're set here today in this matter for a final pretrial, the court's drop dead date. Mr. Paul, can you please update the court?
Yes, I can, Your Honor. So the state and I have come to a somewhat complicated agreement, but I do understand. My understanding is that this case is resolved. I guess my position would be that the case is not resolved in a way that could be resolved by a plea today. The reason for that.
All right, pause right here, because this case is already heading somewhere very unusual. We're dealing with a felony public assistance fraud charge tied to nearly $200,000. But instead of a straightforward plea or sentencing, the attorneys are floating a deferred judgment, added charges, restitution conditions, and a 5-year legal tightrope. This isn't about a dramatic arrest. It's about paperwork, reporting failures, and years of consequences quietly stacking up. The real question is, how does a case grow this big without anyone noticing? And is this agreement justice or mercy? Stay with this one because the details matter.
Is that the agreement is, like I said, somewhat complicated. It involves a deferred judgment of conviction agreement as to the felony that is currently charged. I don't believe that we've formally entered into that deferred judgment of conviction agreement, or at least if we have, it happened fairly recently. I know that my client and I both signed a proposed deferred judgment of conviction agreement that I drafted and I sent over to the state on Friday. I'm not sure that the state has had an opportunity to review that or file it or sign it. So I'll defer to the state as to that. Beyond that, the agreement contemplates additional charges being added and Ms. Belland entering pleas of guilty to those additional charges as well. So I'll defer to the state as to whether or not they believe we can proceed with a plea and sentencing today or need to schedule it for a later date. I will say that a plea questionnaire, I have gone over a plea questionnaire concerning the agreement with Ms. Belland. If the state wants to proceed today, I think we can proceed today. Ms. Belland and I have discussed the plea to some depth, and I think she understands the agreement.
Mr. Schmidt?
Yes, the DJOC is as drafted is good. I think the way you format and draft is actually better than ours, and we're probably going to copy yours in the future.
Well, that's good to hear, Mr. Paul. Good job.
So to be frank, I believe that I stole mine from the Douglas County District Attorney's Office, or at least modified it from the Douglas County District Attorney's Office. But in the field that we are, I don't think it would be a problem for you to steal theirs as I stole theirs.
But yes, I signed it. I can proceed today. I think given the nature of what our victim is, the state of Wisconsin, we're victim rights compliant to do it. It'd just be if the court has time for it.
Yes, I could do that especially because Mr. Harrington would like to have time with Sergio, his client. What is the agreement that's been reached?
I can go through it for the court. So the agreement is essentially that the state will move to add counts 2 and counts 3 to the criminal complaint. Each would be a violation of Wisconsin statute 94693 sub 2, which would be misdemeanor public assistance fraud, both of which are then a class A misdemeanor. As to count 1, the parties will enter into a deferred judgment of conviction agreement. As said, the terms are as follows: that Ms. Belland will plead guilty to all 3 counts, that she will stipulate to the amount of restitution alleged by the state, that conviction of the guilty plea on count 1 will be deferred for a period of 5 years, that she will pay an administrative fee of $150, complete any sentence and or probation on counts 2 and 3, and make monthly payments towards the restitution balance of no less than $300 per month. If at any point during the deferral period the balance is brought to 0, count 1 will be dismissed. If the 5-year period ends, the restitution balance remains unsatisfied, but the defendant has otherwise complied with the terms of the agreement, the remaining balance will be converted to a civil restitution judgment against the defendant, and count 1 will be dismissed. If at any point the defendant goes 90 days without making a payment, the state can move to terminate the agreement and proceed to sentencing on count 1, which is the felony. As to both counts 2 and 3, Ms. Belland will enter a plea of guilty. The parties will jointly recommend the court withhold sentence in favor of 2 years probation concurrent to each other, with standard conditions, as well as a 2-year suspension from the food share program, payment of costs, and monthly payments towards the restitution balance of no less than $300 per month.
Okay, a couple things that I'm seeing pop out with regards to that agreement that may make it unconscionable. One is the fact that I don't believe.
This is a critical moment. The judge isn't rejecting the deal, but she is reminding everyone who actually holds the power here. Even when both sides agree, the court cannot approve conditions that conflict with statute. Notice how the suspension from food share isn't optional, it's mandatory under Wisconsin law. And more importantly, the judge clarifies something huge. Restitution tied to probation never just goes away. If payments stop, probation can be extended indefinitely. That's not symbolic oversight, that's long-term leverage. So ask yourself, is this agreement structured to rehabilitate,
But I don't have
or structured
somebody
to
from the
ensure
state,
compliance at all costs?
in that department telling me, I don't believe that I can grant an agreement where she's agreeing to a 2-year suspension. That can be a private thing of her.
You're
deciding not
actually
to
required
apply.
to order it by Wisconsin statute.
Okay.
It's kind of like DNR suspensions.
Okay, even if it involves children?
Yes. And specifically, her children don't get suspended from the food share program. She does. This is Wisconsin incorporating federal law about it.
For her calculation into it, but her children can still get food share.
I don't know the specifics about how that worked. I assume it is. But
Okay,
I'm just articulating what Wisconsin statute says. They have to order her suspended on any sort of these things from food share. I
All
don't
state-
believe it applies to Medicaid.
okay, not Medicaid, but, okay, but all other state assistance programs, maybe not Medicaid, or just the food share?
Food share. I can actually get you the statutory citation. One second.
Okay, and the other thing that popped out at me is that you may agree that in the end of this, if it's not all paid off, that a civil judgment will be entered. But quite honestly, that's only up for me to decide.
The reason why we would be asking that is I don't think it's realistic to ask her to pay $200,000 in really any period of time when by the documents given to you, it appears she's a homemaker with a single breadwinner being her husband at home who makes $65,000 a year. I checked with the state entity. They said that they're able to collect on civil judgments after they end, which is why I presume to do that.
And they're probably in a better position to be able to collect, but I'm just stating out there that, so she knows, so Ms. Belland knows that when you're on probation and there's restitution attached, only I can release you from that probation. I can extend you infinitely if I don't believe you're making a good faith effort to try and pay that off. And I understand $190,000 plus is a significant amount of money, a lifetime probably to pay that back, if at all.
Okay.
So, Mr. Schmidt?
The statute that we're talking about for the suspensions is 946.92 sub 3 sub B. So it says for first violation, the court shall suspend a person from participation in the food stamp program for not less than 1 year nor more than 2 years, 6 months. For second violation, not less than 2 years and not more than 3.5 years, which is why, we're asking a concurrent suspension. I believe the law allows that. And then that also explains why we have a DJOC on a third count, because the third count requires that they be suspended forever. So that's like the big thing in the DJOC.
Okay, all right.
And I do believe that the court's statement regarding the completion or the end term of the agreement is actually more or less in agreement with what the understanding is. I think the court's language is better suited than how I drafted it.
Thank you, Mr. Paul. And Ms. Belland, you stipulate to the restitution in the amount of $190,562.26.
Yes.
Okay. And you're seated here in person in front of the court. Mr. Paul is by video conferencing. You have a right to say, you know what, Judge, I would feel more comfortable if I could have a plea and sentencing hearing with Mr. Paul seated right next to me. That is your right. So if you wish to wait and have a hearing when he can be here in person, we can do that, and I'm comfortable with that.
No, it's fine.
You understand?
proceed.
Okay, so you're waiving the right to have him in person. So you know that if at any time you have any questions or concerns and you need to speak with Mr. Paul, just let me know and I will briefly stop the hearing. You can go outside and give him a call, okay?
Okay.
All right. You have a telephone?
Yes.
Okay. All right. So you wish to proceed and move forward with the plea and sentencing?
Yes.
Can I have the DJOC, please? Thank you. And I do have the plea questionnaire waiver of rights form electronically filed. And I had reviewed that prior to today. Ms. Bellin, do you need a copy in front of you?
No.
Okay. And in that document, did your attorney thoroughly go over that document with you?
Yes.
Did he read it to you essentially word for word?
Yes.
And do you understand everything completely?
Yes.
Is the agreement that was stated on the record accurate?
Yes.
And that's the agreement that you've reached?
Yes.
And you understand the significance of that agreement?
Yes.
You are pleading guilty to 3 counts. One is that for that sole felony count, and then you have 2 counts of misdemeanor public assistance fraud, correct?
Yes.
Formal motion to add counts 2 and 3.
So made.
Granted. We will need a written information with those contained in it, please. All right, and Ms. Belland, you're pleading guilty to those counts. Did you sign that document? Is that your signature?
Yes.
You are 43 years old. You have 12 years of schooling. You can read, write. You understand the English language?
Yes.
Any drugs, alcohol, or other medications in the last
No.
24 hours?
No.
Any mental illnesses or disorders?
No.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face for each of these crimes?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that first page of the plea questionnaire. It's usually on the first page of our deferred judgment of conviction. I'm not seeing it on that document, but perhaps that's something the state, if you adopt what Mr. Paul drafted, you want to add those on there too, just in case. But on the plea questionnaire waiver of rights form, it does list all of your constitutional rights. Did your attorney thoroughly go over those with you?
Yes.
And do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand by pleading guilty to these crimes, you are waiving those constitutional rights?
Yes.
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes.
Do you understand that here with each of these counts, the state would have to prove on or around between April 2017 and November 2024 for count 1, public assistance fraud, failure to notify agency of receipt of income or assets greater than $10,000, that you received any income or assets and you failed to notify the public assistance agency within 10 days after receiving the income or assets, unless a different time period is required under the applicable public assistance program, and the value of that payment or benefit is more than $10,000, a Class G felony. Do you understand what the state would have to prove as it relates to that matter?
Yes.
Do you understand that upon conviction, you do face a fine of not more than $25,000 and not more than 10 years of imprisonment or both?
Yes.
Do you understand that as it relates to the 2 misdemeanor charges, and they are 2 separate charges, but they are the same, that the state would have to prove the same dates and times and places, that you had knowledge of an event that affected the initial or continued eligibility for your public assistance, and you failed to disclose that event, and you failed to disclose the event with the intent to fraudulently secure public assistance, and that you intentionally made a representation of a material fact in an application for or receipt of public assistance, and that the representation of that material was false when you made it, and you knew the representation of that material fact was false when you made it, a misdemeanor. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty for each of those separate crimes, even though they are the same crime, would be a maximum possible penalty of a fine of up to $10,000 each, or 9 months of incarceration each? Do you understand that?
Yes.
Now, do you understand the agreement as it's been recited on the record?
Yes.
And do you understand that I'm not bound to follow that agreement?
Yes.
Said differently, if I thought based upon the facts of this case, there should be a different sentence, which could include the maximum possible penalty for these charges, I could do that today. Do you understand?
Yes.
Do you still wish to proceed and enter guilty pleas?
Yes.
Do you have any questions for your attorney or for the court before we proceed?
No.
Did you go over that criminal complaint with your attorney?
Yes.
In particular, that section called the probable cause section, where it basically says what happened between that time period and why you were charged with the crimes.
Yes.
For the most part, as it relates to all three of those crimes, are those facts accurate?
Yes.
Are you admitting here today that you did in fact have an intent to fraudulently secure public assistance, and you knew that you were misrepresenting material information?
Yes.
And you understand that you're pleading guilty to 3 separate counts, 1 felony and 2 misdemeanors,
Yes.
and you're guilty of those 3 counts.
Yes.
Mr. Paul, may the court use the probable cause section of the criminal complaint to find a factual basis?
It may.
Has anyone made any threats or any promises to you for you to plead guilty to these 3 separate charges?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he looked at the discovery and discussed that with you?
Yes.
Has he discussed with you a potential for defenses or a lack of defenses in this case?
Yes.
Is it your decision to accept the plea and forego a jury trial?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No.
As to count 1, felony, failure to notify receipt of income and assets, fraudulently obtaining public assistance greater than $10,000, a class G felony, how do you wish to plead?
Guilty.
As to added count 2, the misdemeanor count of failing to notify receipt of income assets, fraudulently receiving public assistance, a class A misdemeanor, how do you wish to plead?
Guilty.
As to added count 3, failure to notify receipt of income and assets, fraudulently receiving public assistance, a class A misdemeanor, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept all 3 of your pleas of guilt. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you. Before I go into, why the agreement, I want to succinctly summarize what this offense is, because a person might see welfare fraud, 10,000 or more in the amount of $190,000, think, wow, that person took a lot of food or that person took a lot of medical supplies. What happened here is about 7 years ago, the defendant's significant other or husband got employed, and she didn't report that he got employed, and for the past 7 years hasn't been reporting his income. He's employed in Minnesota at a pretty decent job. The court knows from the court-appointed paperwork. At some point, his employer opted into reporting income to the federal government. That's an optional program. Employers can choose to do that or not. When they chose to do that, what that triggered was the next time that Ms. Bellin called in to update the information for welfare, give, assets, income of the household, who's working, it automatically flagged with the federal database, the optional report one said, hey, this person reported they are working here according to STIPs from the employer. So they went back, saw that he had been working there 7 years. They sent it to a different department to calculate, okay, if we knew about this income, would it have affected the benefits in terms of food share and Medicaid, Badger Care as it's called in Wisconsin, and if so, how much? That is what this number represents. It represents that they got extra food share that they wouldn't have got otherwise with the income reported of a pretty small amount of the portion of this. The vast, vast majority of this $190,000 is insurance costs. It's not even service. It is the way Medicaid and Badger Care works is there is a separate entity that gets paid with federal Medicaid pass-through dollars through Badger Care to just say a person's covered. So that is what the large amount of this is. It's not necessarily an amount where you'd say, because Ms. Bellin got it, someone else is without. But it's still a thing where the state government and the federal government are out the money because it actually got paid to a non-state entity. I learned a lot myself about how Medicaid worked through this.
That money actually got paid to someone from our state?
Yes.
Okay.
So the state is out the money, even though it's for coverage instead of per se an actual service. So
Okay.
I want to make sure that's understood with why the amount is as large as it is in 7 years. As the court's probably aware, as many people are, insurance is extremely expensive if you try to get it privately.
This explanation changes how you view the number. We're not talking about bags of groceries or stolen checks. We're talking about insurance coverage, valuations that accumulated quietly over 7 years. That doesn't erase responsibility. But it does explain how someone can cross a felony threshold without feeling like they took 6 figures out of a system. The prosecutor even admits this case taught him how Medicaid accounting works. So here's the real tension. Should intent matter when the financial impact is massive? And should ignorance soften consequences when the law says reporting was required every single time?
This is a 43-year-old defendant with no prior history. I don't know that she comprehended, the value of the insurance she was getting from getting it in this way. So I don't know if she knew how fast she was racking up this money because she was already at the highest felony in less than a year with how Medicaid calculates that. So what the goal of this agreement is I should add too, she has no alcohol issues. She has no mental health issues. She has no drug issues. This is not a person with criminogenic needs like that. So the goal with this is to structure something where DOC can look and see, is there a need that can be addressed that could have been the nexus for this or the behaviors? Because as the court can tell from my summary there, she had to report for a very long time that her husband wasn't working, which is not just one act, it's quite a few acts. If I wanted to, I could have broken apart this one felony I charged into, by my count, maybe up to about 84 counts is what I thought could be done on the high end if I really wanted to. If I did it by reports and payments and things like that. I think this encompasses the behavior better. I think with the way it's structured at the DGOC on the third count, she does get an immediate punishment relevant and tangible to the offense with the pretty long suspension of a couple years. And she has to be on her best behavior because if that DGOC gets revoked, one, obviously it's a felony conviction. 2, she could face up to prison on it. But 3, permanently getting revoked from the food share program would be a really big permanent consequence. So I think that incentive hanging over her is going to be very effective and being more upright with reporting the assets and incomes and not trying to be, clever or anything with it like that. So I'd ask the court to follow the agreement for that. I've confirmed with, before I even did this, I confirmed DOC. Well, you might have noticed the DGOC says make certain minimum payments to the Department of Corrections. That was negotiated through. We made sure that would work for the defendant. I checked with DOC. They love that idea. They love the ability to set it through the DGOC because as the court's probably aware, we have to do financial pay hearings for probation per se. But with the DGOC, we can kind of circumvent that and ensure at least some amount gets paid. Obviously, if the court's sat there and done the calculations, it's still a very small amount in terms of the percentage of the total amount of the overpayment. But the goal is something that's, something reasonable to actually expect this defendant to be able to pay given her background and her family situation, but also something that's high enough that, it'll be felt in the pocketbook. It'll be felt as a consequence, and restitution takes on a pseudo criminal, pseudo civil consequence. That's part of also why, we're not asking for any upfront jail or incarceration on any of these today. Like I said, she has no criminogenic needs. So I'd ask the court to follow the agreement for those reasons. I think as structured, this is the best way to do some punishment for this offender while appreciating her rehabilitative potential and lack of criminal history, but also giving, DOC the chance to collect. The court, if it wants to get involved, I think it's alluded, this is a choice. And if not, if it follows our agreement exactly as we say, I've already talked with the state entity that deals with collections. They're fine with collecting and confirm they can if this gets converted to civil judgment, and which is what we're asking. Thank you.
Okay, thank you. Is there a way to separate the dollar amount for food versus insurance?
Yes.
And while I wait for that, how old are your children?
12 and 10.
And I don't need that right now. You can look for that. But Mr. Paul, argument?
Yes, Your Honor. So I think the crux of this case, or the crux of the recommendation to the court, really balances out the lack of criminogenic needs that the defendant has, and the sort of, I think it was alluded to as a pseudo criminal, pseudo civil punishment. I think of it more as a positive punishment in the psychological sense of the word, in terms of what the minimum payment agreement really does, and that it sets out a framework where Ms. Belland can make those payments, and if she does so for the period of time that the court sets, she doesn't escape with no punishment. She is still a convicted criminal at the end of this, and she will have gone through probation. But she really does avoid the massive sword over her head that is initially charged in this case, which is the felony charge. And I'm not by any means saying that it is a wrongly charged case. I think the amount of restitution, or the dollar amount that we're stipulating to, shows that this was a significant event. But as the state shows, it is much different than if someone took $200,000 out of a bank or something along those lines. That's not the intent that Ms. Belland had. I don't think that Ms. Belland even had an awareness of the consequence of what was going on and what her misinformation caused in the system. But it that only matters to some extent. And what matters in the other extent is that this had consequences for the state of Wisconsin, and Ms. Belland was not entitled to those services in the way that she would have been if what she was reporting was true. So I think this agreement really balances out the, I don't want to say complete lack of criminogenic needs of the defendant, but pretty close. And the protection of the public would be the term that would be used in determining a sentence in a standard case. I'm not sure if it's protection that we're necessarily talking about, but it's justice in what we're talking about here, and that there's funds that went where they weren't supposed to, and that this agreement essentially helps to rectify that misdoing. So I'd ask the court to adopt the agreement. That's all that I have.
Thank you, Mr. Paul. And it is protecting the public interest, but it's also an awareness to the public that, hey, this is what can happen if you don't accurately report your information and you do so and fraudulently obtain public assistance. So I think that it's twofold. Ms. Belland, what do you do all day?
I help my parents and my mother-in-law. My mother's-in-law has a hard time with her health. Clean my house, go visit with my parents. I will be looking for a job. That's not that I don't want to, but I have back issues, so I have to be choosy, I guess you would say, with what I do pick. So,
All right. And you understand that if I follow this agreement and you have a minimum payment of $300 a month, that you are still responsible to pay monthly your attorney fees.
yes.
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 Okay. Because otherwise, that's another thing, because the county has fronted, or they will front that bill, and you need to, it's like a loan from the county. You
Yeah.
need to pay it back.
Yeah.
Okay. All right. Is there anything you want me to know, Ms.
No.
Belland?
No,
Any remorse or anything that you
I mean,
had
I'm sorry for
afterthoughts?
what I did. I didn't intentionally.
You didn't realize what would
Yeah,
happen?
yeah.
Okay, all right. This is a serious crime in the respects that it is taking from people in need, or where $190,000 could have been used for someone else, another family in need. But it's not the most serious crime in terms of crimes, because you haven't went out and robbed somebody, you didn't carjack anybody. It's not driving while under the influence and causing an accident, or not causing an accident, something along those lines. So it has that serious yet not serious attachment to it. I think that this agreement is appropriate, and I am going to adopt the agreement because it puts supervision over you. It's there, so you would need to make your monthly payments. You'll still need to make your court-appointed monthly payment. This is it. For some people, they may say, well, this is just a slap on the wrist, but it is not. This is going to be taking away from your ability, where you may have a need for public assistance, but now you're not going to be able to get that, or get limited assistance for the period of 2 years.
This is where it all lands. The court adopts the agreement, 5 years under a deferred felony judgment, 2 years of probation, a mandatory suspension from public assistance, and a restitution plan that could follow this defendant for decades. No prison today, but no clean slate either. The judge makes it clear, this isn't about branding someone a villain. It's about accountability, deterrence, and protecting public trust in assistance programs. And now we want to hear from you. Was this outcome fair, too lenient, or exactly right? If you found this case as eye-opening as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
With regards to the count 1, that felony, I will adopt and receive that deferred judgment of conviction. It is a period of 5 years. So that's 5 years of oversight, 5 years of having to pay $300 a month guaranteed, and having the court here to oversee and make sure that that happens. You owe $150 immediately to the district attorney's office.
I just paid $100 when I walked in, so.
Excellent. Make sure you pay that 50 within that amount of time, that 60 days. That's the number one reason I see them asking.
Within 60 days?
Yes,
Okay.
within 60 days.
Okay.
That's the number one reason I see the district attorney's office asking to revoke this agreement and set it
Do I
for
have a
sentencing
set date every month that I need to pay it by, or is just in the month?
within the month, by
Okay.
the end of the month.
Okay,
And that's the same with your court-appointed attorney's fees by the end of the month.
okay,
Probation will be collecting that $300 in restitution. So you have to talk to probation about when that is, but my guess, by the end of the month.
okay.
Okay. So I'm adopting it for count 1, the felony. With regards to both of those misdemeanors, I will place you on probation for a period of 2 years with a withheld sentence for both of those. Okay. So the 9 months for each of those is hanging over your head. Not that you need anything else, any other big hammer, but it's still going to be hanging over your head. With the conditions, I am going to say gainful employment. Doesn't mean full-time, but gainful employment to pay back the amount that you owe for restitution, court-appointed attorney's fees, court fees, things like that. So gainful. I am going to order with this 10 hours of community service.
Okay.
Okay. And that's to be done by the end of the year. So you have 1 year to do that.
Oh, okay.
Not by this year, sorry. The end of 1 full year.
Okay.
So you'll have until next, I'm going to say to be done by December 31st of 2026.
Okay.
Okay. And that's not a lot. 10 hours isn't that much, but it's enough for you to understand, again, this is serious, and it's another way for you to give back to the community. So gainful employment, absolute sobriety. I don't think we have issues there. Any programming that you need, that the department says that you need to undergo.
Okay.
I don't see any other needs, but the department may. And just so you know, I just got a message from my clerk that you did pay $100, but you paid it to the clerk's office, not to the DA's office.
Okay.
And
Okay.
so
I'll get it up here by the end of the month. so.
Okay, and you do need to pay that straight to the DA's office, that $150 a month.
Okay.
All right, but that 100 will go to pay down your attorney's fees,
Okay.
so that'll be good to go. With restitution, again, you pay to the Department of Corrections. So take care of that. With your attorney's fees, you pay to the clerk's office.
I have a quick question.
Yes,
For employment, can I do cash jobs, like cleaning jobs and stuff like that?
I'm fine with any job as
Okay.
long as you can show that you are gainfully working
Okay.
and making money.
Okay.
So that's fine with me, as long as you pay the amount you owe every month, okay?
Okay.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. So when you're done here, you're going to go to the sheriff's department, provide that. This is something, at least with these misdemeanors, where you can request it be expunged from the system through a written letter to the Department of Justice.
Okay.
Mr. Paul can help you with that if you want to look into that. I am going to set you for restitution court because it's such a high amount of money owed. At least until I'm assured that you're making your payments and you don't need oversight or me to watch and make sure. So I'm going to schedule you for April 13th at 2:30. April 13th at 2:30. That's an in-person hearing.
Okay.
If you've been making all of your restitution payments, all your court-appointed fee payments, you'll be good to go. You may not need to come at the next go around.
Okay.
It's 4 times a year. So
Okay.
you may not need to come back. I just want to make sure that everything is going according to this plan.
Okay.
Okay. 2 years suspension from the ability to have public assistance. I do need $443 in fines and fees for count 2. For count 3, I'm only going to order the DNA surcharge of $200. I will waive the rest of the court costs. And that's going to be hanging over your head because that's the last to be paid. Restitution goes to be paid first. And again, I'm not as concerned about the court costs, the attorney's fees, and the restitution. I am, and we need to make sure that we try and stay on top of that.
Okay.
I believe that covers everything. If you fail to pay your fines and fees and restitution, not only will a civil judgment be entered against you, but the court will issue a warrant. You could sit up to 6 months in jail. And because of this high amount of restitution, even when you're off of probation, you may have to continue to go to restitution court.
Okay.
Okay, so we'll deal with that when we need to. Am I missing anything, Mr. Schmidt?
Not for me.
Mr. Paul?
I don't believe so. The only thing that I want to address is being that Ms. Belland is continuing into restitution court. I'm assuming you want my appointment to be concluded and me not continue to represent her in restitution court.
Correct, yes.
Okay.
Yes, you're not needed for restitution court. It's just to monitor restitution to make sure that they're paying. There may be sanctions if they're not paying, but at that time, she can decide if she wishes to have an attorney or not.
Understood. Thank you, Judge. That's all that I have.
All right. You must report to probation immediately after you're done giving your DNA. Are you still on State Road 70?
Yes,
Telephone ends in 0466.
yes.
All right, you can come get your things, go provide your DNA, go to the probation. We are good to go. Thank you. We are adjourned.